Good afternoon, class. Welcome to our online lecture for CRW2601. Today we are covering the last study unit of the module, which is study unit 16. That study unit specifically deals with attempts, incitement, and conspiracy, or what is commonly referred to as inchoate crimes. I welcome you to this lecture, and as usual, we will get on to the recap. Briefly, we are, as you can see on the screen, on the last section of the study guide. Not too long ago, we covered Unit 14 and 15 combined. It is not necessary to regurgitate what was communicated during those interactions. We covered briefly the doctrine of common purpose, went into great lengths about different forms of participants. We covered the basis on which common purpose is extended, either by prior agreement or active association, and the case that you do need to know. We also went into covering the aspects of accomplices and accessories after the fact. And what I stressed at the last lecture that we had was the importance of the definitions of each of the participants. You cannot say somebody is a perpetrator unless you can justify by using the definition that either they satisfy the definition of the crime by their conduct, their state of mind and circumstances, that is, they are liable according to the ordinary principles of liability, or they are liable because of the application of the doctrine of common purpose. It's only on those two bases that you can conclude that somebody is a perpetrator. If that fails, then you can go further to say that, or ask the question whether X furthered the commission of the crime by somebody else. If that is the case, then that person is an accomplice. Now, we also stressed that accomplice liability arises usually and quite competently in crimes that are defined or described as formally defined crimes. Now, formally defined crimes are crimes that prohibit, that expressly prohibit a type of conduct, that expressly prescribe the circumstances in which that conduct ought to take place. So in those types of crimes, it is easy to identify who a perpetrator is, and it is unlikely, because of the nature of that crime and the fact that it has to be committed by either that person's hands or that person's particular body parts, it is not possible that the act can be imputed to somebody who did not commit that crime. So under those circumstances, that individual would likely be an accomplice who just assists the other person to perform that crime. We also spoke about accessory liability, and both accomplice and accessories after the fact have one common characteristics. They are accessory in nature, meaning that you cannot have an accomplice and you cannot have an accessory after the fact without identifying a perpetrator. So in that sense, there has to be a perpetrator in order for you to identify who an accomplice is or who an accessory after the fact is. So without further ado, let's get into the content of Unit 16. As stated, we will cover 3 particular crimes. 2 of them will cover with some degree of depth. The last one we will not so much so, but let's start first by covering attempt, and we are on page 220 of the study guide. As I have also always indicated when we begin these lectures, I encourage you to firstly observe the learning outcomes of each unit. So the learning outcomes in this unit on page 221 are described as follows. When you have finished the study unit, you should be able to demonstrate your understanding of the principles relating to anticipatory crimes by expressing an informed opinion whether certain conduct amounts to a punishable attempt to commit a specific crime. Now, as we indicate in the background articulated there, criminal law does not concern itself only with completed crimes. It also, because of the preventive theory of punishment, it also deals with anticipatory crimes, or crimes that are not fulfilled, but where we can say that the harm that is caused, the disruption to society that is caused by not nipping that crime in the bud before it's completed is so harmful that it must be prevented. So this is what the purpose of attempt and incitement in particular and conspiracy seek to deal with. They are focused on dealing with nipping because it's unreasonable to wait for the police to expect the police to wait until a crime is actually committed. If there is sufficient information that can lead to the police arresting perpetrators of potential crimes before they are actually completed, that is better than actually waiting for those crimes to be successfully completed. So attempt, conspiracy, and incitement are referred to as inchoate or anticipatory crimes, since they deal with forms of particular punishable conduct that anticipate or precede the actual completion of the crime. And the reasons I explained there in the next paragraph there, that the reason for preventing these crimes lies in the preventive theory of punishment. The law seeks to prevent not only the completed crimes, but the attempts or the anticipatory forms of conduct that are also punishable. And we cannot expect the police to really wait until a crime has already been perpetrated. So that last paragraph is illustrative of that. It says, imagine the police hearing that a group of persons is preparing to rob a bank with the use of firearms. They know who the would-be robbers are, and they watch them get into their car and drive armed to the bank. If such anticipatory conduct were not punishable, the police would be in the ludicrous position of having to wait until the completion of the crime, perhaps involving the shooting of innocent people, before they could apprehend the robbers. Now, moving on to the issue of attempt. There are 4 different types of attempt that we break down in this unit. There is, in no particular order, I will say there is the completed attempt, there is interrupted attempt, there is the attempt to commit the impossible, and then there is what is called voluntary withdrawal. It's also a form of attempt. Now, you will see on page 222, there is a definition, a broad definition speaking to what an attempt is. Now, that particular definition comes from the case of Scumby, R versus Scumby, whereby the court spoke of 2 broad forms of attempt, whereby firstly, somebody who commits or engages in conduct that is not merely preparatory, but has reached at least the commencement of the execution. And then there is a person who commits an attempt whereby, even though the commission of the crime itself is impossible, okay, a person is guilty of attempting to commit a crime even though the commission of the crime is impossible if it would be possible, it would have been possible in the factual circumstances that she believes exist or will exist at the relevant time. So definition 2 speaks of attempt to commit the impossible, whereas definition 1 really speaks about interrupted and also voluntary withdrawal. Now, in the case of R versus Kumbi, the court also spoke about a situation whereby the accused has done everything that he or she went out to do, but did not complete the crime either because of lack of skill or because of an unforeseen circumstance. Now, that brief description speaks of the form of attempt that's called completed attempt. So if X, for example, fires a shot intending to kill Y and misses Y, X has done everything that he or she set out to do to kill Y, but due to lack of skill, did not succeed. Likewise, let us say that X beats Y up, intending to kill Y, but Y is rescued and goes rescued at the hospital and survives. In such a situation, X has done everything that he sought to do to complete the crime of murder, but because of the intervention of the medical personnel at the hospital, Y survived. So in those situations, it is easy to say that all forms of completed attempt, where we can safely say X has done everything he or she sought to do, all those situations are completed attempts, and the person concerned will be liable for an attempted crime, either an attempted murder or attempted robbery or any other form of attempt under those situations. So completed attempts are not difficult for us to deal with. It is very, very easy. You just ask yourself the question, has X gone out to do everything that they set up to do, but did not manage to achieve that successfully, either because of lack of skill or because of the intervention of medical personnel or any other situation concerned. That is completed attempt. In those situations, X will be guilty of the attempted crime. Now, the controversy arises where we have the situation whereby X has not done everything that they could do to complete the attempt, either because they were interrupted before completing the crime, or they voluntarily withdrew from completing the crime. Now, in both those instances of interrupted attempt and voluntary withdrawal, the law has come up with certain principles that are important for you to note. Now, in the principles are the same in relation to both interrupted attempt and voluntary withdrawal. But the leading case with interrupted attempt is R versus Scumbi. In the case of Scumbi, X had gone and bought a tin of inflammatory material and had petrol and poured the petrol inside through the door of the house underneath and around the house, preparing to light the match. Then X had put the tin down next to the tin of inflammatory material, right at the petrol that was poured all over, and was then interrupted immediately by a police constable at the time and arrested for attempted arson. And the court had to decide in Scumbi whether X is liable for attempted arson. the court stated that it is important in such situations to distinguish between acts of preparation and acts of execution, or what is commonly said to be the end of the beginning vis-a-vis the beginning of the end. So the end of the beginning is, you must distinguish between acts that only fall under preparatory stage, and the beginning of the end would be acts that would naturally be defined or considered to be part of the execution of the crime or the commencement of the execution. The court went on to say that it is important to adopt a broad or a wide interpretation of commencement of execution, that there are no bright and clear lines that can be indicated and applicable for all cases. It is important to adopt a value-based judgment as to whether X's acts, when they were interrupted, fell within the execution stage or the commencement of the execution. So in those situations, the court then decided that if, for example, the act only falls under mere preparation, there can be no liability for attempt. But if the act interpreted, the act at which X was interrupted can be interpreted as having, if an inference can be drawn that X had finally made up their mind and was in the process of executing that towards the completion of the crime, then despite the interruption, X will be guilty of an attempt. So on the facts of Scumbi, the court concluded that X was guilty of an attempted arson because at the time when he was interrupted, he had already made up his mind to follow through to execute the act. So those are the interesting facts and principles that come out from the case of Scumbi. Before I get to this attempt to commit the impossible, let me firstly deal with voluntary withdrawal. As I said, the principles are the same. You can have a situation whereby X is interrupted, as in the case of Scumbi, before completing the crime, or you can have the case where X changes their mind from following through and completing the crime. And this is what happened in the case of Hlatwayo. In that case, X was a domestic worker who was making porridge for her employers. And in the course of making porridge, X poured a poisonous substance inside the porridge, but was seen by another domestic worker or domestic helper, and that domestic helper threatened to expose this X to her superiors. So X then decided to take the porridge from the pot and spill it, and then wash the pot with water to make as though he or she was not going to follow through with it. But she was nevertheless arrested and was charged with attempted murder in that instance. I will read portions of that judgment. Very, very short but interesting judgment. It said the following. The lawyer on behalf of the accused argued that here the accused desisted or withdrew of her own free will. And the court went on to say, it seems to me quite clear that a person who intended to commit an offense has done certain acts leading towards the commission of the offense is not necessarily exonerated because he changes his mind. It all depends on the stage at which he changes his mind. If he changes his mind before his acts amount in law to an attempt, that is, before they amount to the commencement of the consummation, then he cannot be found guilty of an attempt because his acts did not amount to an attempt. But if he changes his mind at a stage where his conduct already amounts to an attempt, that is part of the consummation or the commencement of the consummation, then it does not avail him to say that he changed his mind and desisted from his purpose. So the court on the facts then went on to say the porridge was being cooked on the stove and was intended for the use of the household. She put caustic soda into the porridge, knowing that it was poison, and at that stage she intended that the porridge should be used by the household. The porridge was in a place where it was likely to be used as food for the household. She had done all that was necessary for her to do to complete her purpose. If she had taken no further steps, the employer would have come into the kitchen and got control over the porridge, and she might have used it for household purposes. So on that basis, that being so, it seems that the accused had committed an attempt. In my opinion, the fact that she changed her mind afterwards because of the other accused who threatened that she was going to inform the others about it does not exonerate this accused. So on that basis, the accused is rightly convicted of attempted murder. So in that interesting set of facts, the accused had tried to go through with a plan, was threatened by one of her co-workers that she will be ratted out, decided to withdraw from that, but according to the court, the assessment is that she, at the time when she withdrew, she was already at the stage of execution of the plan. It was not a case whereby she withdrew at the point where we can still say she's in preparation. Now, a quick thing to note here is that there's no such thing as a negligent attempt. All forms of attempt are determined intentionally. So the only fault requirement that applies to attempt liability is intention. So that now covers the situation whereby we've done completed attempt, considered the principles of it. We have done interrupted attempt and voluntary withdrawal. The only difference between the two simply is the circumstances under which the crime was not completed. In the first instance, the instance of interrupted attempt, it is because X was interrupted. In the second instance, voluntary withdrawal is because X decided to change his or her mind. But the principles otherwise are the same. The question is, at the stage of either interruption or at the stage of withdrawal, can we say that X's conduct was still in the stage of preparation, in which case it would not be attempt, or was it already at the stage of execution, in which case it will be an attempt, regardless of the fact that the completed crime was not fulfilled. Now, when we talk now about attempt to commit the impossible, which is the final aspect of attempt liability, we are not dealing with situations whereby the crime is factually possible to commit. We are dealing with a situation whereby the crime is factually impossible to commit, either because the means that were used to achieve that crime will not achieve that crime. For example, let's say X thought that they were using poison, not thought, sorry. Yeah, thought that they were using poison into the porridge, but they were just using bicarbonate of soda, for example, or they poured sugar instead of the drug that they were hoping to put into the porridge or a certain drink. In those instances, the means used cannot bring about the desired result. There is also the instance where attempt to commit the impossible arises, where the impossibility arises because of the object, either because X thought that they were killing a human being, whereas in actual fact they were shooting at a corpse already. The person concerned had died already when X tried to commit their act, or X was shooting perhaps thinking that they were shooting at a human being, but maybe they were shooting at a shadow or at a stump, a tree stump, for example. That is a case whereby the object concerned cannot be the subject of the crime. The impossibility arises from the object concerned, not because of the means used. Now, the interesting case that decided what the principles to be applied are is the case of State versus Davis. It's a very, very important case. Interesting types of judgments that were given in that ruling. And there was in that case of Davis, what had happened is that at that time in the 1950s, it was still a crime abortion was a crime. Procuring an abortion was a crime, and therefore the accused was convicted of attempting to abort the pregnancy of a woman. But the evidence disclosed that the fetus had already died in the womb before the accused had attempted to perform the abortion. So the question was whether an accused in such a situation is guilty of an attempt or not. Now, in those situations, the court went into great detail to discuss impossibility. You know, the lawyer on behalf of the accused had tried to argue that one must distinguish between absolute impossibility and relative impossibility. So absolute impossibility would seem to be where the result aimed at could simply not be attained by any means on the facts before the court. Whereas relative impossibility would seem to be where the results could be attained, but the means employed were ineffective. So in this instance, for example, the lawyer on behalf of the accused tried to argue that the situation here was an absolute impossibility because on the facts concerned, the fetus was already dead. And to talk about aborting what is dead is a non-starter. So the outcome cannot be achieved. It was a situation of complete absolute impossibility. It's almost like saying that you are holding somebody guilty of something that is not a crime, attempting to commit something that actually is not a crime. But relative impossibility is a situation whereby let's say, for example, in that instance, the fetus was it was still possible to achieve the abortion, but the means employed to achieve it proved to be ineffective. That was argued by the lawyer to say that in those situations, the accused should be guilty of attempted crime, despite the fact that there is impossibility. But the majority of the court, by 4-1, decided that such distinctions are completely unhelpful. And in the leading judgment of Justice of Appeal, Justice Schreiner, he concluded as follows in relevant part. To sum up then, it seems that on principle, the fact that an accused criminal purpose cannot be achieved, whether because the means are in the existing or in all conceivable circumstances inadequate, or because the object is in the existing or in all conceivable circumstances unattainable, does not prevent his endeavor from amounting to an attempt, provided that at the time concerned, their acts fell under the stage of execution. So in other words, we are still not punishing people for mere thought or mere intention. There must be an overt act or conduct that can still be said to fall under the stage of execution. But ultimately, what makes the person liable is the moral guilt of the accused, because objectively speaking, there is no conceivable harm that can be achieved through something that is impossible. So what the law seeks to punish in the case of attempt to commit the impossible is the moral guilt of the accused in such situations, because in the absence of the factual impossibility, the accused had done everything that they sought to do to achieve what they thought would end up to become a crime, but for the factual impossibility. But now in Davis, they made the exception to say that if what is attempted or what is thought to be attempted is not a crime, for example, let's say X thinks that adultery is still a crime in our law and tries to commit adultery. In such situations, that's the person cannot be held guilty of an attempt because the adultery is not a crime. So a putative crime where X thinks that what they are doing is a crime, whereas it is not a crime, an attempt to try and commit such a putative crime, whereas objectively speaking, there's no crime of that nature that exists in our law, does not count in the aspect of attempt to commit the impossible. So please bear in mind the distinction that if the mistake is about the law, then there cannot be a punishable attempt. But if the mistake is simply about the facts, in the sense that either the means used cannot achieve the outcome, or the result or the object concerned is not amenable to that crime. For example, X beats what turns out to be a corpse, thinking that it's a human being. The object is impossible to achieve in those instances, just as, for example, X tries to kill somebody with a toy gun. The means used are ineffective to achieve that. Now, as we did in the last unit, we covered, we had a bit of a self test or self activity here. Just have a look at it, because the question deals with the aspect of attempt to commit the impossible. So both the question and the answer is there. I will not delve into it. but we'll move to two other crimes that we'll cover briefly. Let me first please note that these crimes, for example, are also not, you need not study them for the examinations. They would have been relevant for assignment assessment. So both conspiracy and incitement would not be questions that are in your exams that you'll face at the end of the year, because they are areas that were open to us to assess you on the assignments. Now, let's deal firstly with conspiracy and get that out of the way before coming to the interesting aspect of incitement, for which we actually also have a recent Constitutional Court judgment of the Economic Freedom Fighters versus, I think, the National Prosecuting Authority, whereby Mr. Malema found himself in a situation with the law, and because he had made some utterances to say that people should occupy land, they should just occupy land whenever they need to. Just to take some of those words into interesting context, let me just move to those particular portions of the charges. So on 16 December 2014, at an elective conference, he is reported to have said, can occupy all the of. All right. I thought I had lost you here. Can I have a show of hands again if my audio is still on? All right. Thank you. Thank you. All right. Okay. But in those interesting cases, thank you very much. In another instance of the charge, he is reported to have said, if you see a piece of land, don't apologize, and you like it, go and occupy that land. That land belongs to us. And in another connection, after his court appearance, he made a statement to a crowd to say the following: occupy the land because the state has failed to give you the land. If it means going to prison for telling you to take the land, so be it. I am not scared of prison because of the land question. We will take our land. It doesn't matter how. It's becoming unavoidable. It's becoming inevitable. The land will be taken by whatever means necessary. So those were his utterances that formed part of the charges of incitement. But before I get there, let's touch the issue of conspiracy and get that aspect out of the way before touching on what incitement actually means. So for conspiracy, which is on page 231 of your study guide, both conspiracy and incitement are regulated by sections 18 of the Writers' Assemblies Act, 17 of 1956. Also, the Writers' Assemblies Act also extended the crime of attempt to cover statutory offenses. So before that act was enacted, it was not clear in our law whether one can be liable for an attempt to commit a statutory offense. But because of the Writers' Assemblies Act, Section 18, it also covers attempts to commit statutory offenses. And the same principles would apply as with all common law offenses. So in that section, it says any person who conspires with any other person to aid or procure the commission of or to commit any offense shall be guilty of an offense. Now, note that the offense concerned is conspiracy. It is independent of the actual crime concerned. So conspiracy is a standalone crime. The provision indicates that the provision indicates the following. It does not differentiate between a successful conspiracy as like one that is followed by the actual commission of the crime and one not followed by any further steps towards the commission of the crime. So in other words, once there is an agreement and entering into an agreement, that suffices for the crime of conspiracy. While the parties are still negotiating with one another, there is not yet a conspiracy. A conspiracy is only achieved or complete once we have a meeting of the minds. And it is not necessary for the crime of conspiracy to be completed that the state prove the commission of any further acts in execution of the conspiracy. Now, the intention requirement is another interesting part here. It is subdivided into two parts or two components, and the state has to establish both. There must be an intention to conspire, and there must be an intention to commit a crime or to further its commission. So if only one is satisfied, then a conspiracy is not met or achieved. Now, the crime of conspiracy as well had a very interesting sanction or a section in the sanction where it said that one who is guilty of conspiracy may be sanctioned to the same punishment as the person who actually completed the crime that was the subject of conspiracy. Now, later in the case of incitement, the same principle also seems to arise. And this was the subject of the Constitutional Court judgment, as I referred to the Economic Freedom Fighters case versus, let me just indicate the full name of that case. It is Economic Freedom Fighters and another versus the Minister of Justice and Correctional Services and another. This was the judgment that was decided on the 27th of November 2020 in relation to the crime of incitement. And so incitement is covered by Section 18(2)(b) of the Writers' Assemblies Act, which reads as follows: any person who incites, instigates, commands, or procures any other person to commit any offense shall be guilty of an offense. And it goes on to say that upon conviction, that person may be liable for the same sanction as the one who performed the completed offense. Now, what does incitement mean? The term incitement was defined in the case of Nkosiyana. And in that case of interesting facts on page 233 of your study guide, X had suggested to Y, who was a policeman, that they murder Mr. Kaiser Matanzima of the Transkei. However, Y, being a policeman, wanted to trap X and brought in another police officer who pretended to be the assassin recruited by Y. So in that instance, they even went as far as the accused even went as far as to give them money to try and persuade them not to withdraw from the plan. Ultimately, they were caught in that police trap. And the question before the court was whether incitement requires an element of persuasion. Is it necessary that Y be persuaded to perform the crime upon the incitement made by X? That was the argument that was raised on behalf of X, that because we had a police trap, it was probably unlikely that Y and Z, being police officers, were persuaded, and therefore the crime of incitement could not be performed. But the court said that no such element of persuasion is required. All that is required in terms of incitement is the following. An inciter was described as somebody who reaches out and seeks to influence the mind of another to the commission of a crime. Close quote. So an inciter is somebody who seeks to influence the minds of others to commit crime. Now, immediately understand and recognize how Mr. would fall foul of that particular crime, given his position and given his influence. He sought to influence the minds of others to commit particular crime, which was trespass in that instance. So the court went on to say in Kosiana, whether the other person Y is capable of being persuaded is immaterial. Neither do the means that X uses to influence or to try to influence carry any weight. Now, in the High Court, what had happened is that the High Court found that the crime of incitement, although it infringed the right to freedom of expression, was a reasonable and justifiable limitation in an open and democratic society, according to Section 36(1) of the Constitution. But it ultimately held that the punishment itself, to say that the inciter may be liable for the same kind of punishment as one who completed that crime, that was unconstitutional, and on that basis declared that section unconstitutional to that extent. And because a High Court had declared the section unconstitutional, according to the Constitution, that declaration is only valid if the Constitutional Court confirms it. So it had to go up to the Constitutional Court, and at the same time, the economic freedom fighters and Mr. Malema also appealed. So the judgment is very interesting and comprehensive. All I can say in respect of the judgment, let me say the following first and foremost, though. The court was split by 8-3. So in the majority judgment written by Mogoeng CJ, in which 7 other judges agreed with him, it was held that the crime of incitement does infringe on freedom of expression. It was held that the crime of incitement the infringement cannot be justified to the extent that it specifies that any offense can be the subject of the crime of incitement. It did not distinguish between serious offenses and offenses that are minor. And to the extent that it was such, it was judged by the majority to be overbroad, or it went overboard in terms of its method of preventing crime. On the other hand, the minority judgment, which was written by Majid J, and to which Jafta J.A. and which other judges? Jafta J and Titli J concurred. She found, or Judge Majid actually found that the crime did not violate the crime, although it did limit the right to freedom of expression. That limitation was reasonable and justifiable in an open democratic society. Now, just to express my views on the two judgments, I respectfully align myself with the minority judgment in this instance, and the concerns that they've raised are very valid, because what they do is that they actually contextualize properly what the crime of incitement covers. So instead of going the route of saying freedom of expression is this extremely high premium right that's protected by the Constitution and needs substantial and compelling justification, the minority said that our Constitutional Court, in terms of its jurisprudence, has said that there's no hierarchy of rights. We view rights as intertwined collectively and interchangeable. So to use the analogy of the United States, where the United States Constitution places the right to free speech as high premium, and places a hierarchy on different rights, our Constitution does not do that. So on that basis, the minority went as far, and the interesting thing about the minority judgment is that it actually properly defines what incitement is. So it follows the accepted, established jurisprudence of what incitement is, whereas the majority seems to just brush incitement with a very broad stroke without recognizing that the particular crime of incitement is very particular, it's very limited. It does not it's not a substantial infringement on free speech because of other considerations that are involved in the prosecution of that crime. So that's my 2 cents as far as that. I align myself with the minority view in this instance, but that is the case. Ultimately, the law is made by the majority, and the majority judgment found that what was necessary is that instead of the crime just saying any offense, it was necessary to put the word, or to read in the word, serious. So it now reads, any person who incites, instigates, commands, or procures any other person to commit any serious offense, whether at common law or against the statute, shall be guilty of an offense. Interestingly, the court unanimously did not confirm the order of the High Court. So in other words, the court did not agree with the reasoning of the High Court that it was not available for a court to exercise its discretion to convict a person of incitement to sanction a person who's committed incitement of the same crime as the one who actually went through with the completion of the crime concerned. So the court did not agree with the High Court, but decided differently in terms of what was constitutional or unconstitutional about the crime. So therein concludes our session for today in terms of the study unit 16. I will now open up the platform for questions. Hello, Emmanuel Malupe. You can unmute your mic. Emmanuel Malupe. Okay. John Pedro. John Pedro. You can unmute your mic. Okay. All right. I see another hand here. TP Sintumule. Can you unmute your mic? Hello. Okay. Okay, Nosipiwe Machaba, can you unmute your mic?
Hi, I just have a question.
Yes.
That you actually mentioned in the State versus Davis case, right?
Yes.
I heard you talk about absolute impossibility, which was obviously based on the facts, and then you said the other one, it means that the means were ineffective, but I didn't quite get what that other one was. Can you just repeat that for me, please?
Oh, what I was doing is that I was trying to explain how the lawyer on behalf of the accused tried to argue that the court must distinguish between absolute impossibility and relative impossibility. Now, absolute impossibility, according to the argument, was where the objective concerned cannot be achieved based on the facts absolutely. So in those instances, according to that argument, X who tried to procure an abortion on a dead fetus already, the argument was that X should not be liable in those situations. Now, the situation of relative impossibility would be a situation whereby, let's say, the means that X tried to procure an abortion or tried to kill the fetus, the means that were used were ineffective. And let's say the fetus maybe survived. In those instances, the argument was to say that an accused can be liable for that. But the court rejected the distinction between absolute impossibility and relative impossibility and said that basically it is best to say that impossibility can arise either because the means used cannot achieve the result, or it can arise because the object concerned cannot be for example, like a corpse cannot be the subject of the crime of murder.
Okay. No,
Yeah.
thank you.
Okay. All right. Nosipiwe, can you mute your
sorry, yes, I need to lower my hand as well.
and mute your mic. Okay, Paul Skosana.
Thank you for the opportunity. Thank you for the opportunity. May you please clarify between interrupted attempt and voluntary withdrawal?
Okay, Sintumule, I will take you, and then Paul, I'll come back to you.
Okay.
Paul, can I ask you to just mute your, okay, thanks for muting your mic. Let me respond to Sintumule. Interrupted attempt is when an attempt is interrupted, I guess, just to put it like that, whereby, for example, X is trying to achieve a certain crime, but is interrupted because of the intervention of a police officer or another individual. Yeah, in those situations, that's interrupted. Voluntary withdrawal is when X, by his or her own volition, changes their minds towards against following through with the commission of the crime. Is that clear?
Yes, it is. Thank you so much.
Okay. Paula Skosana, you can unmute your mic. Paula Skosana, you can unmute your mic.
You've answered me, sir.
Oh, okay, okay, all right, okay.
Thank you.
All right, thanks. All right, Miss Zeng.
Yes, afternoon, Mr. Ramosa.
Afternoon.
Yes, I have two questions. First is regarding, okay, I trying to understand for the attempt, when we talk about the end of beginning and the beginning of end. I'm just taking example, okay, when we talking about, you know, like rape, as per the criminal law, sexual offense and the related matter Act 32 of 2007, because it a statutory crime, you know, for rape if there is attempt. But what I want to ask, okay, if somebody, for example, X stalking Y for you know several times, okay, that is still not like recognized as attempt. Am I right? It's only when X attacking Y, then we can see that is attempt. Am I right? I basically want to ask him if stalking with intention to rape cannot be taken as an attempt unless there is like a further commission, for example, like attacking or something, right?
Yes, I think generally speaking, if generally speaking, for an attempt, there has to be conduct that can be said to be part of the execution of the crime. So you can't hold somebody guilty of an attempt based on their intention or just their thoughts. It is important that people put their thoughts into action. Does that answer you?
Yeah, but basically in my question, I basically want to ask him if stacking is not stalking is not enough as a commission or as an action. I'm saying whether stalking is only a preparation, basically, I think in this case, am I right?
All right, I'm kind of just missing exactly what you are saying.
Yeah, basically I'm saying if X trying to rape Y, so X is stalking, you know, with Y, you know, for some time. Okay, it's just keep following, you know, Y, because he's trying, you know, to find a chance, okay, maybe to seize her and to do whatever the bad thing. So I'm saying, unless he attack Y, then can be regarded as attempt. I just trying to how you say, to find the answer, okay, whether, you know, my understanding is correct. Only stalking is not, you know, sufficient enough to be identified as attempt. Am I right?
Okay, all right, let me say the following. I am unfortunately I am struggling to audibly hear your particular query, Ms. Zeng. Can I ask you to post it on the comments so that I can actually answer it whilst looking for on the comment section?
Okay, I will do. No problem.
Thank you very much. I appreciate that. Sorry for that. I think there's just an interruption with my audio or something like that.
And I have a second question. Actually, I already put on chat section. Maybe you can just see it, you know, later. It's
okay.
Basically regarding incitement. Yeah, I'm trying to understand whether the person's identity, you know, like if X incite Y, whether Y's identity, you know, matters. Because I think, for example, when we talk about incitement, there is two kind of situation. One is, okay, like the X inside an innocent person. The person has never had any crime in his mind, but the X is inside, is influence, okay, Y, trying to commission, like a crime, like the case, okay, we are talking. And there is another kind of case, like if X inside, okay, a professional criminal, for example, like a contract killing, that means X hiring a professional killer, trying to kill somebody. Or for example, like X inside the drug dealers, okay, to sell the drugs, okay, to him by giving, like a high price. So basically, they still influence the other, but the other part actually are professional criminal. Whether there is a differences, okay, when we talk about the incitement.
Oh, okay. The definition of incitement, according to our law, is one who reaches out and seeks to influence the minds of another or others to the commission of a crime. So the status of the person who's been incited, whether they are dangerous or they are not dangerous, or they are part of a criminal organization or any such, is immaterial to the liability of the inciter. The question simply is whether X, as the inciter, reached out and sought to influence the state of mind of another to commit an offense.
Thank you.
Yeah, okay.
I got it. Yeah.
Oh. Darlene Hendricks.
Thank you. My question is, earlier you mentioned about if X stabs a corpse and he can't be then charged with murder because the person's already dead. But then can he be then charged with maybe perhaps abuse of a corpse or something like that?
X would be guilty of attempted murder because in such instances, although it's factually impossible because the object that X targeted is not a live human being, but a corpse. X's state of mind and X's conduct had reached the stage of execution. So on the basis of the Davies case, and the principles there, X would be guilty of attempted murder. There is also the crime, indeed, of violating a corpse. So yes, that's a statutory offense, and X would be guilty of that as well.
Thank you.
All right. Let's see who's next. Okay, Letlogonolo Vincent.
Thank you for the opportunity, sir, and good afternoon, everyone. I just wanted to know, you talked about withdrawal, withdrawal as well as interruption when it comes to attempt. Now, I just want to make a scenario. I just want to be clear of the two attempts, the distinction between the two. Let's say X is in the process, has already started to rape Y. Maybe he's using force, managed to put Y down, undress Y, but before X penetrates Y, without any interruption, decides, no, let me stop this. How can you categorize that? Where does it fall? To my mind, the action had already started, but in the process before it was completed, then he decided to withdraw the action. Thank you very much.
All right, thank you, Letlogonolo. Although graphic, admittedly, I should say the following. I think, as the court said in the case of Scumbi, it is not helpful to try and focus on the act or the time at which X either withdrew or the time in which X had changed their minds, to try and determine whether the act is part of preparation or execution. What is important is to look at a common sense approach of the whole situation and say, can it be inferred that the conduct of X, even at the time when X withdrew, was part of a series of expected acts that would be said to be part of consummation. And so in that instance, I would say, for example, that X's conduct, despite the change of mind, would amount to attempted rape in that situation, because despite the withdrawal, X's conduct was part of a series of actions that can actually be dubbed as falling under execution of the crime. Does that help?
It does. Thank you very much.
Okay. Okay, I can't pronounce this one. Guayise, I can't pronounce your name. Can you help me firstly with the pronunciation of your name?
Oh, Siqibo.
Sorry?
It's Siqibo.
Siqibo. All right.
Yes, yes.
Okay. Thank you very much. Go ahead, Mr. Guayise.
Oh, good afternoon, sir.
Afternoon, sir.
Like, I have a simple question. Is voluntarily withdrawal a defense to a charge of attempt? Like, maybe I don't understand what exactly is voluntary withdrawal.
Okay, voluntary withdrawal is when X has a change of mind with going through with his conduct. So when X changes their minds and decides not to want to continue to complete the crime. So that's voluntary withdrawal.
Okay.
Okay, to answer your question, it is not a defense if the change of mind happened in the stage of execution. It's not a defense to attempt if the change of mind happened at the stage of execution. But if the change of mind happened in the stage of mere preparation, then it's not an attempt. Does that answer you?
Yeah, I got it. Okay.
Thank you. The next person I see is Clive Mugweneni. Clive, you can unmute your mic. Clive?
Hello, sir. All
right.
Yes, I have two questions here. My question is first on incitement. Yes. So the first question is, if X tries to incite Z to commit a crime, and then Z refuses and instead reports to the police, can X still be charged with both incitement and conspiracy to commit a crime?
X can be charged with incitement because X did, with intention to incite, seek to influence the mind of Z to commit a crime. So that is sufficient as far as the crime of incitement is concerned.
Okay.
Yeah.
And then my second question is on attempt. When it comes to attempt, what degree do the courts decide whether an act constitutes assault, GBH, or attempted murder? Does it depend on the weapon used or the degree of the victim's injuries?
Thank you for the question. Assault with intent to do grievous bodily harm, as I understand the content of CRW2602, under that section, the most important thing there is the intention. So the bodily injuries need not be severe for one to be able to say that this is an assault that was committed with intent to do grievous bodily harm. Of course, it's easy once you have the severe injuries to conclude that there is assault GBH, but they can just as much be assault GBH even if the injuries are not severe, provided that there is an intention or proof of intention on the part of the perpetrator to commit grievous bodily harm. And the courts look at certain criteria and the circumstances in which the crime was committed to draw an inference as to whether the intention concerned was to commit grievous bodily harm.
Okay.
Does that help?
Yes, I think that answered my question. Thank you, sir.
All right. Thanks, sir. The next person is Mangaliso.
Good afternoon, sir.
Afternoon, Mangaliso.
How are you doing, sir?
I am well, thanks, in you.
I'm trying, sir. Sir, my question is slightly very easy. I want to say first, thanks a lot for these classes. They did help a lot since we are going through these tough times of COVID-19, lockdowns, etc., etc. So I've seen here that you have more or less wrapped up the study or the subject per se. My question is quite simple to say, are we going to be having maybe more revision classes or how so going forward?
Okay, thank you. Your question is very valid, Mangaliso. So we will continue with revision classes. I believe Professor Molemao is in agreement with me on that. We will continue with revision classes, as is the case with the CRW2602, which is currently also under a process of revision sessions. We will, and the revision classes will continue at the same time as the normal class. So we will communicate with you as to which areas of revision we will cover. Perhaps even, I think, perhaps if you can do the same as we did with the CRW2602 and see if you can post in the chat which particular sections of this module would you appreciate having a revision next week on. So I would appreciate any particular comments on the chat specifying which sections either that could be of interest to you or even that are of difficulty or challenge to you. We are amenable to considering that we don't have to go unit by unit as per class. We can formulate the revision classes according to the students' needs and demands.
Okay, thanks, sir.
Okay. The next person is Chifango.
Good afternoon, sir. How are you?
I'm fine, thanks. And you? Can you help me pronounce your name?
It's Chifango.
Chifango. Okay. What does it mean?
It's vendor, and the direct translation in Sepedi would be Sifako.
Oh, Sifako. Okay.
Yes.
So Sifako ki thunder ne?
No, Kisigi the hail.
Oh, hail.
Yes.
Okay. Yeah. Yeah. All right.
Okay. And so I just wanted to ask. It's a follow-up question, maybe to something that's quite topical. Is when we're talking about, or in relation to a question that was asked in relating to voluntary withdrawal, as where you mentioned that it cannot be a defense if the withdrawal took place at the execution phase. So, but let's say this sort of act was part of a broader team. So in terms of investigations that would have went on, how far can the person who withdrew at the planning phase be added in terms of the crime, whether in terms of being an accomplice or in terms of participation or in terms of being an accessory to the crime? I hope it's clear. Thank you. Thank you, sir.
Thank you, Chivango. The question is very clear, and it actually talks about the issue of dissociation from a common purpose. So it's more relevant to that item or that topic, whereby one of the accused perhaps tries to raise the defense that they disassociated themselves from the common purpose, and therefore should not be held liable of the crime through the doctrine of common purpose. There are principles that the courts have come up with. This is one of those sections in your study guide that are for self-study and are not for exam assessment. But one of the principles that are there is that the withdrawal has to be voluntary. The withdrawal also has to have taken place at the earliest opportune time, because the deeper you go into participating with your co-accused, the more action will be required from you to demonstrate that you are disassociating yourself from the common purpose. And that action may amount to either frustrating the execution of the plan, tipping the police officers timelessly as to what your co-conspirators are engaging in. It's a value judgment, and basically it's more or less the same as the issue of attempt when it comes to voluntary withdrawal. The same principles apply. You have to apply a value judgment to assess as to whether at the time when the withdrawal took place, were you at the stage of execution, or were you still at the stage of mere preparation? Hope that answers your question.
It does. Thank you very much, sir.
Okay, pleasure. Lituma Busaliti. Lituma Busaliti.
Yes, good afternoon, Mr. Ramosa. I just want to know, so I've seen like sometimes when there are maybe strikes outside, sometimes people will decide to ban a dead person, a dead cop. So now, in that case now, do you know that is dead and everything and they ban it? What will be charged with?
There is the crime of desecration of a corpse, or violation of the corpse. It's a statutory offense. Hello?
Yes, or no, all right, I was muted. Sorry. All right, it's fine then. I think you have answered me.
Okay, no, pleasure. Ruben, I will take your hand. Ruben. Hello, Ruben. Ruben, if you're able to unmute yourself, please try and attempt to do so. But in the meantime, let me take Gladys Puleng Kaba. Hello, Gladys.
Hello.
Yes.
How are you, sir?
I'm fine, thanks. And you, Gladys?
I'm good. My question is, I just want to know, why is factual impossibility not regarded as a complete defense?
Oh, okay. That's interesting. Okay. Do you want to follow through? Sorry. Gladys, is there?
Yes.
Do you have a follow up on that?
I was just doing some reading, and then yeah, that's what I come up with, but it's not on the textbook here.
Okay. Well. All right. Okay, before I answer you, Ruben, you can unmute yourself from your side. I've already assisted you to be able to unmute yourself. So whenever you are able to unmute yourself, please try to do so. Back to you, Gladys. Factual impossibility is not a defense because, and I think the best way for me to answer it is to reflect on the statement of the judge who decided the Davis case on the issue, because it is important that the law also puts weight on the moral guilt of the accused. So, for example, if somebody tries persistently to achieve something that just by the mere fact that there is a factual impossibility that he would not be aware of when he tried to commit it, that person has got sufficient moral culpability to be held accountable for their actions. We cannot, according to the court in Davis, fruitless endeavors cannot be said to just be unpunishable. For example, let's say, for example, you have a situation whereby accused people are escaping in a motor vehicle, and they are chased by a police armored vehicle, and one of the accused fires a shot towards the screen, either the front windscreen or the side window, to try and kill the driver. And unbeknownst to that particular accused, the window is bulletproof. So just because the window is bulletproofed, but the person has actually fired a shot to try and actually kill or harm the driver, that person should not be should not escape liability for what they intended to do and actually went as far as to try to achieve, but for the factual impossibility. So do you understand the principle that underlies the punishment of an attempt to commit the impossible?
Yes, sir, I do.
Okay.
Thank you.
All right. Okay, let me take Ruben's question on the chat. I see Ruben has tried to post something. It says, I just wanted to ask if it's possible when we do the revision, can it also serve as exam prep? Okay, yes. I think all forms of revision can serve as exam prep. And let me be quite specific what I mean by exam prep. I'm not necessarily suggesting that the type of revision and type of questions that we'll be dealing with will be questions that you will face in your exams. You are reminded that your exams will be multiple choice in format, but the forms of multiple choice are such that you will also be examined or tested on your ability to apply your knowledge. So you will have sufficient scenario-based questions whereby your options then will have to be a deduction from an attempt at applying yourself to the scenario. So when I concede that it can also serve as exam prep, all I'm really saying to you is that it can only help you to grasp the concepts better, to grasp the definitions better, and to understand the case law better. But apart from that, it cannot go beyond that to try and maybe give you a scope for the exam. That's not what I'm suggesting. And then to the question by Ms. Zhang, she says, if the crime does happen, the inciter X is also the indirect perpetrator for such crime, as he is talking to the influenced person Y as the tool to achieve that crime. Yes, if the crime is if the crime itself is completed, then one can actually say that X and Y acted in common purpose, provided you can say that there was a prior agreement between X and Y to achieve that particular crime. Then there will be sufficient common purpose. And then X will be a perpetrator just as much as Y would be a perpetrator. The concept of indirect or direct perpetrator, remember, as I indicated, is immaterial to one's liability. Somebody who influenced another to commit a crime or who hired an assassin to commit a crime on their behalf will be a co-perpetrator just as much as the one who actually perpetrated the crime. Melissa Jane Vivier says, stalking in my mind would be preparation because the act has not yet taken place. All right, I don't know if in our law there is, I think there is a common law crime still called seduction. But I also want to go as far as to say that stalking would even go as far as being a crimen injuria, because stalking is an invasion of one's privacy or an invasion of one's personal space. So it can amount to a crimen injuria. Let me try and tackle some of the questions that are here. All right, let's see. Good afternoon, Mr. Ramos. I would like for you to clarify what this means. The court has to distinguish between the beginning of the end and the end of the beginning. Now, those two concepts are the beginning of the end. Okay, let me start first with the end of the beginning. The emphasis here is that the end of preparation. So when is the stage of beginning, as in like the stage of preparation, coming to an end? That would be the end of the beginning. And then when the court said the beginning of the end, it speaks of the sequence of events that amounts to the consummation or that leads towards the end. So the operative words there are the last words. So if beginning is at the end, then we're talking about preparation. If end is at the end of that sentence, we're talking about consummation. It's just an interesting phrase to speak about X of preparation vis-a-vis X of execution. Good afternoon. I am yet to receive my study material for this module. I know this may be late, but I thought the delay is due to COVID. May I please be assisted? Sure. I really can't help you, Cheryl, with that. And Lebohang, I also really can't help you in that respect. I think I can only encourage you to try and contact the dispatch department. In that respect, I'm really sorry, and my heart really goes out to you and everyone else who's in the same situation. As much as possible, if it is at all possible, try to do what you can on the screen of your your computer or laptop or whatever device you have with the study guide. If it is also possible, try and see if you can perhaps work together with a fellow student who is able to access the study material, or is able even to photocopy and print out such material for you. Ms. Zeng goes on to say that if X is driving a car circling in a neighborhood, his suspicious move attracted the residents' attention and was reported. He was then stopped by the police patrolling car. The police found his carrying a bag in his car with all kinds of tools, knives, wig, mask, gloves, and rope, etc. Could X be charged of interrupted attempt to burgle or burglary, as he didn't reach the stage of finding a targeted house yet? Interesting. No, I think much more would be needed for the establishment of an attempt at housebreaking. I think that's the proper refinement of the crime concerned. We're talking about housebreaking with the intention to commit a crime inside. So at that stage, I don't think it would be a stage of execution yet. X would probably still be at the stage of preparation, and I would suggest perhaps that the police wait just a little bit longer to check what more is X trying to do before moving in. That way they can catch him maybe at the stage of execution proper. Let's see. Yes, conspiracy is not part of the exam. It is fine if you don't study it. Notando. Please note that the slides, as always, will be provided for you on the My UNISA site, along with the recording. Ms. Zeng said, does another's identity matter in incitement? For example, contract killing in terms of hiring professional? No, it does not matter. I managed to answer that. Let's see any other. Takane says, if X give Y a lift and Y was carrying a bag, on the way they come across a roadblock. During the search, they found rhino in the bag of Y. I assume that would be rhino horns. Will X be charged for giving Y lift without searching Y? No. X, I doubt if X would be charged necessarily with any crime for giving Y a lift. I think it's important also for us to prepare beforehand for the revision to engage meaningfully with you, Mr. Ramosa. Okay. Thank you, Ruben. I think we will definitely consider posting something prior to make sure that there's prior preparation and that the engagement can be a discussion instead of a one-way street. What does the law have to say about witchcraft? There is an instance where someone threatened to bewitch someone. Toby, I appreciate your question, but you'd have to give me a bit more about that particular instance. Lebohan says, I have been using the PDF version. I don't know if there's anyone here from Sprite View. Thank you for trying. Okay, you can download. Okay. Okay, then I see the last point here. Okay, Christian, I note your hand. I will give you a chance there. TG Tlatwayo says, sir, my assignment dates for submission do not correspond with assignment dates in my tutorial letter. The assignment unique codes correspond. However, on the portal, the dates do not correspond. I've escalated this because the marker commented that I submitted incorrect assignment. Please help me escalate the matter. Mr. Shatwayo, please send us an email with your specific query so that we can handle your particular query outside of this particular platform. The Tokonolo Vincent says, and during the search, why denies having the bag? In other words, why say the bag does not belong to him? As I said earlier to that particular question, Tokonolo, there would have to be a bit more to that factual scenario. I cannot deduce or make a conclusion as to what X will be charged with in such a scenario, because merely helping somebody by giving another a lift is not a crime known to our law. All right. I do not see any further hands that are up. Going once, going twice. Okay, I see some hands now going up now. Gladys, is that an old hand or are you still asking a question, Gladys?
I do have a question.
Okay.
So my question is, in a case whereby a person shoots his gun at an innocent victim and the gun happens not to be loaded, would that person be charged with attempted murder or what?
Okay, yes, that would be attempted murder because that is a classic case of an attempt to commit the impossible because the means used cannot achieve the outcome sought. Is that clear?
Okay. So also I can say that it's will that be an example of factual impossibility, if I may ask?
Exactly. It's factually impossible because the means that were used are impossible to achieve the outcome.
Okay, thank you very much, sir.
Thank you, Gladys. Ms. Zheng, I will take you. Ms. Zheng? Ms. Zheng?
Hello?
Hello?
Yes, Mr. Robinson?
Yes, Ms. Zheng.
Okay, if you don't mind, I have one last question.
Yes.
I did have, a question in the chat. Hello?
Hello, Ms. Zheng. I think there's some interruption.
Yes. Can you hear me now? Can you hear me?
Yes, I can hear you. Please try again.
Okay, Mr. Ramosa, I published a question, in the chat, a long question. Basically, I have given a scenario. The thing is, okay, I basically want to know when I review, okay, unit 14, I just trying to understand, for the common purpose, doesn't mean the person has to join, before. Sorry, doesn't mean the common purpose has to be, like participate in before the commission of the crime. It also can be possible, like joining in the middle of the commission of the crime. That is basically what I trying to find it out whether my understanding is correct. That is why I have just thinking a scenario I put on the chart. If you can go through it. Hello.
All right, I can hear you. I see it says, can the doctrine of common purpose apply to persons who are committing public violence? According to the definition elements of that crime, people must act in concert. So does that mean each member's act is imputed to the other? That question is correct, Clive. The doctrine of common purpose applies to the crime of public violence. Let me see. All right, Ms. Zeng, to answer your question, and I think I managed to get hold of it. Yes, common purpose, remember, can be established either by prior agreement or by active association. Now, the active association can take place at any point whereby the crowd maybe is committing a particular crime and then somebody gets in and joins in. Now, the question now as to whether that person is a perpetrator or is a mere joiner in will depend on the principles concerned and the time of that person's intervention. So if that person joins in at a time, for example, if we speak about murder, at a time, for example, where the fatal wound has not been implemented or perpetrated, then that person can be guilty of murder because they actively associated themselves with the conduct of the group in murdering the victim. So the acts of the group in causing the death of the victim will be imputed upon that person who merely comes in and joins in. But if that person joins in at a time whereby the fatal wound has already been struck, then that person cannot be guilty of murder and their liability will have to be determined individually in that instance. I see your scenario is very, very long, Ms. Zhang. Let me rather do this. I'll read it. It says X and Y are friends sharing the rented house. One day when Y gets home from work, he found X kidnapped a girl. Y gave X 5,000 Rand and told him to stay in the guest house for the night and not to tell anybody. Y took the money and went to a guest house nearby. Later evening, he called X saying, I took a big risk agreeing with you for what you are doing. You must have gained more money and benefit. I need more. Once agreement was reached, okay, I think that's the question. Once agreement was reached, then Y became co-perpetrator from accomplice as he then associated X in the crime, sharing the common purpose. Okay, so the question is whether you are correct in saying that Y becomes a co-perpetrator to the kidnapping by agreeing to accept the money.
Yes, because Mr. Ramosa, because when I thinking about this scenario, I'm just thinking, okay, before Y called X, to ask him for more money, only if he take the money and stay outside, he is basically compliant because he doesn't fulfill all the crime definition elements of kidnapping. He's basically furthering X, commission of the crime, but he doesn't, he himself, by only take the 5,000 Rand and get away from the house and just pretending, nothing happened, that, qualifies him, as only a compliance. But if he called, X, asking for more money, basically means he is reconciled himself, to the whole, commission of the crime. That makes him, sharing the common purpose. So he become the co-perpetrator. That is my understanding. I'm just trying to make sure my understanding is correct. Thank you.
Okay, no, thank you for that question. Y would not be guilty of kidnapping because, according to your scenario, Y already found that X had kidnapped the girl. So at best, Y could become an accessory after the fact to kidnapping because Y unlawfully and intentionally sought to aid the perpetrator to evade liability. Do you understand that?
Okay, I did not take as accessory because accessory basically is doing something, after the crime is done. But the kidnapping, when he saw the girl, in the house, that means the kidnapping is still happening. It's not ended because kidnapping, this is continuous, like a commission. It's not like assaultment or like a murder. You just finish one strike. The commission of the crime. Finish. That is why I did not recognize him. Recognize Y as accessory. But I think Y actually, if he only takes 5,000 rand and goes away, that means a accomplice. It's not accessory. But if he is asking for more money, he's basically joining in, associating, himself, with X in this whole thing. Means he's mentally, agreed with what X is doing, and he's asking, to share the benefit out of it. That makes him, like a co-perpetrator, in this case.
Okay. I think you may have a point there, and it really depends on the particular factual scenario. So I responded to you based on the initial scenario. If as you stated, Y found that X had already kidnapped someone, then X is the perpetrator, and by X giving Y 5,000 rand and telling Y not to say or tell anybody of what is taking place, the best that Y can be in those situations would be an accessory after the fact to the crime of kidnapping by X. And even if, okay, you go on to say that Y perhaps ask for extra money or needs more. Perhaps you may be right that Y then will go beyond accessory, but I think the best case scenario is accessory after the fact. Okay. It might be a huge leap to say that Y is also guilty of kidnapping.
Okay, thank you, Mr. Ramasa.
Thank you. All right, thank you everyone for your engagements. I see another question from Robert. Okay. Yes, sincere apologies for irrelevant question. Robert, there's no question that's irrelevant. I think we can all benefit from any questions that comes to mind. Is it a crime whereby someone refuses to provide his or her physical address in order for the sheriff to attach possessions for non-payment in the small claims court? All right. Okay, Robert, I think this sounds a bit more personal, and I think I would rather prefer not to give any advice on real life scenarios that people are generally going through, because for these things you really need people that are already practicing attorneys, and you need to approach them directly and seek advice from them, because they are best qualified for that purpose, and they carry also the risks associated with incorrect advice or incorrect processes of action. So I wouldn't want to find myself being the subject of litigation for having given incorrect advice. So I think it's best that you speak to an attorney as to your matter, Robert. But with that being said, thank you everyone for participating on this online lecture. The revision classes will continue next week We will communicate timelessly, as Ruben suggested, what we will cover next week, Wednesday. And we will try to make sure that we adequately post something that will help you to prepare yourselves for that, so that we can have a fruitful engagement. Thank you very much for taking your time and being available online. Until next week then, the recording and the online and the slides will be available on the My UNISA site. Please check at least before or by the end of tomorrow. It takes a little while to access the recording from the system and upload it for you to have it available. So your best bet is to check in the evening of tomorrow. Thank you very much for your availability, and may you enjoy your afternoon.